Ed Slott and his team recommends not naming the trust as your beneficiary for your retirement accounts. Can you explain your take on it?
Welcome to Barry's Bites. Please join our host, attorney and financial advisor Chris Barry.
So Ed Slott, and I'm a big fan of Ed Slott. I've participated in his elite advisor training program where we'd meet 3 times a year, get like 400-page binders of all the different things that's new in the IRA world. And so, yeah, I remember as I was at the Ed Slott events and him talking about this, understand just first his role. His role is a CPA. So he's really looking at this from a tax perspective, and he's looking at it from a perspective of people screw things up a lot. So the issue is we have these, we call them qualified accounts like IRAs, 401ks, 403bs. And let's for now just focus on them being pre-tax, meaning you haven't paid any income tax. And so what would happen is that when you turn 70 and a half, you would have to start paying taxes. You'd have to start taking out what's called required minimum distributions, RMDs. And so now you would have to take out a portion and pay the taxes at some point. Well, then the Secure Act was passed, and it actually pushed back the RMD age from 70 and a half to 72. So now you have to start taking out RMDs at age 72. And actually right now, past the House, we have Secure Act version 2, which is saying now your RMDs are going to be at age 75. This isn't law yet, but this is probably where we're going to be. But that's not why Ed Slott says not to name the trust as beneficiary. Like with the IRAs, typically what we do, and same with 401ks, 403bs, is you're the owner. You have to be the owner. Can't be anyone else. All right. Then primary beneficiary. So if you were to pass away, typically we would have the primary beneficiary be a spouse, because then you could do what's called a spousal rollover. And then the contingent beneficiary. And so this is where Ed Slott and myself differ, and I'm comfortable with that. And I'll tell you why. We typically recommend when we're doing documents and planning for our clients, we typically recommend naming the trust as the contingent beneficiary. And I'll get into why. But here's the thing. So prior to the Secure Act, when we named someone other than a spouse as a beneficiary of the IRA, they could do what's called a stretch IRA. So they could stretch out the taxes over their lifetime. So if you left like a pre-tax IRA to a 10-year-old, their RMD, because they would have a required minimum distribution, might be like 1%, and it could grow at 3% or 4% or 5%. So the RMDs, you're almost creating this like lifetime income stream for your beneficiaries if they're young enough inheriting these IRAs. So we would do like a lot of stretch IRA trusts, in fact. But what the Secure Act said is no more stretch. Instead, all the taxes have to be paid within 10 years. So that's kind of the current law. Now, here's the thing. And this is why Ed Slott would say, don't name a trust as the beneficiary. Because to get that stretch that we used to have, it had to be what's called a designated beneficiary. And this is kind of dry tax stuff. But I just want to clarify why I actually differ from Ed Slott on this. And Ed Slott's a lot more famous than me. It has to qualify as a designated beneficiary to get that full stretch. And guess what? Some trusts may not qualify as a designated beneficiary. And if that's the case, all the taxes have to be paid within 5 years. So you're looking at naming a designated beneficiary for full stretch, or if it's not a designated beneficiary, all the taxes have to be paid within 5 years. So his concern is there's a lot of attorneys out there doing trusts that don't understand this, or a lot of advisors that don't really understand this. So his concern is if you don't have a well-drafted trust, then all the taxes would have to be paid within 5 years because the trust didn't qualify as a designated beneficiary. Here's why I say that's fine, but in our practice, we're naming the trust as a beneficiary because our trust always qualified as a designated beneficiary because of the language that we include in there and because we avoid some of the pitfalls. So we were doing, prior to the Secure Act, we were doing stretch IRAs, specifically doing a specific trust for the IRA to stretch it for like grandkids. But even our trusts now, they all qualify as designated beneficiaries. So we still get the full 10-year stretch that is allowed as a designated beneficiary, whether you name someone individually or you name the trust with our trusts, at least, it qualifies as a designated beneficiary, so you get the full stretch. That's why Ed Slott does not recommend naming the trust, is because he looks at it from the tax perspective, and people go to him with like a lot of the problems or screw ups. And so there's a lot of times that the trusts don't have the necessary language to be able to stretch it out the full amount, which now is 10 years thanks to the Secure Act. So he was just being conservative, knowing that there's good attorneys and bad attorneys and good trusts and bad trusts. And so his generality is to say, you know what, it's not worth naming the trust. And then the other reason why it's really important to name the trust, typically with a lot of our trusts, is because our trusts don't always say it goes just outright to the beneficiary. If that's the case, you can just name the beneficiary as a beneficiary designation. What a lot of our trusts do, especially our legacy and castle trusts, is we build in the opportunity for a lifetime of asset protection for our beneficiaries. So whatever they inherit are protected from divorces, creditors, bankruptcies, and then whatever they keep inside of the trust would flow down to your grandkids versus going to in-laws. That's very different than naming your child outright on your IRA. So that's the big reason why, even though we can only stretch it 10 years now, we still name the trust as the beneficiary. And worst case, the IRA, the taxes are paid, but the proceeds could still remain in the trust. So there's a very beneficial reason why we name our trust as a beneficiary of the IRA, because we give this opportunity for a lifetime of asset protection to the beneficiaries. You name the child outright on the IRA, they're going to lose that. And then the reason why Ed Slott, America's CPA, who's been on PBS, says don't name a trust or have second thoughts about the trust, is because he's seen too many situations where attorney either isn't aware or doesn't include the language inside of the trust to get that full stretch. So now the full stretch, whether you name a person individually or you name a trust, is just 10 years. But with our trusts, they do qualify as designated beneficiaries, so they still get the full 10-year stretch.